Thanks, everyone. Moving on to our next topic, our headline is Navigating Foreign Law Issues in Recent Swaps Litigation. Tom Wood and I are going to talk about the recent slew of cases that have thrown up interesting issues of law concerning the capacity of Italian local authorities to enter into interest rate swap contracts. And after briefly summarising the issues and the decisions of the Commercial Court and then the Court of Appeal, we wanted to focus on what we consider a distinguishing feature of that litigation, which is that the issue of capacity and authority was governed by a foreign law, in this case, Italian law. And whilst litigating foreign law is an everyday experience in the commercial court, given the importance of foreign law, and very often the content of that foreign law will make the difference between winning and losing a case, we'd actually like to spend a bit of time focusing and discussing about how English judges approach questions of foreign law and how best it is for parties and their lawyers to present that foreign law to our judges. Before we get into those foreign law issues, I'm going to hand over to Tom and invite him to summarise the issues and the decision in the Venice case.
Thank you, Jasbir. So Venice is the most recent case in this line of cases before the Commercial Court involving banks and Italian local authorities dating back to 2009, when interest rates collapsed following the financial crisis. The proceedings concerned long-term interest rate swaps between the Commune of Venice and two Italian banks under the terms of the Is de Master Agreement, governed by English law and subject to English court jurisdiction. The banks wanted declaratory relief as to the validity and enforceability of the swaps in anticipation of claims that Venice was looking to bring before the Italian courts. Venice's defence in the English proceedings was that the swaps were invalid because of alleged breaches of Italian financial and public laws. Its primary argument, as Jasbir has alluded to, is that it lacked capacity under Italian law to enter into the swaps, which, if correct, would mean that the swaps were void as a matter of English law. Venice also counterclaimed restitution of the net amounts it paid to the banks under the swaps. Now, until the Venice case, none of the Italian local authority challenges to the validity of swap transactions based on arguments under Italian law had succeeded before the English court. But not long after the proceedings commenced, the joint division of the Italian Supreme Court of Cassation, that's the highest civil court in Italy, gave a judgment in an unrelated case known as Cattolica, concerning interest rate swaps under Italian law. In one section of the judgment, the Supreme Court declared that Italian local authorities only had capacity to enter into derivatives which were for hedging purposes, but not derivatives which were for speculative purposes. Unsurprisingly, Venice amended its case to rely on the Cattolica judgment, and in particular, the apparent novel rule against speculative derivatives. And there were therefore three key questions for the English court at trial. First, was there a rule of Italian law that local authorities could not enter into speculative transactions? In other words, did Cattolica represent Italian law? Second, and if so, as a matter of English law characterization, did the rule in Cattolica go to Venice's capacity to enter into the swaps? And thirdly, were Venice's swaps speculative as a matter of Italian law? Now, those issues were the subject of detailed expert evidence at trial, written and oral, before Mr. Justice Foxton, from Italian public and civil law experts, all of whom were academic lawyers. On the first question, the judge found that the effect of Cattolica was that Italian local authorities could not enter into speculative derivatives. In making that finding, he accepted that the Italian Supreme Court had made a very significant change to Italian law, for which there was no apparent basis in any of the underlying legislation. However, while such a profound change of law by a court might be objectionable when viewed from the perspective of an English lawyer, and while many academic authorities in Italy considered Cattolica to be wrongly decided, the judge did not feel able to conclude that it didn't represent Italian law. On the second question, the judge held that the Italian law restrictions recognised in Cattolica were, as a matter of characterisation, provisions which went to Venice's capacity or substantive power to enter into the swaps. They were not merely prohibitions, which, as a matter of conflicts law, would only go to the material validity of the swaps, which would be a question of English law. As for whether the swaps were speculative, it was common ground in the proceedings that there was no Italian law test or definition of speculation, and the judge therefore proceeded to evaluate whether the swaps were speculative as a matter of fact. He concluded that they were, essentially because they were structured on terms which enabled Venice to restructure a prior swap without making any payment to its outgoing bank in respect of the swap's negative mark-to-market value. The end result of all of those conclusions was that the judge held that the swaps were void and Venice was prima facie entitled to restitution. But it wasn't quite a case of death in Venice for the banks, because on the restitution claim, the judge found that the banks could in principle rely on a change of position defence. That's because the banks had done what banks commonly do and hedged their exposure to Venice in the market by way of back-to-back swaps with third-party banks. And to the extent that the defendant banks had effectively paid over interest rate flows to their hedge banks, which corresponded with the interest received from Venice, they would be able to show a change of position. That's an interesting topic for a talk on another day, but I'll now hand back to Jasbir to summarise the Court of Appeal decision.
So the banks appealed Ms. Justice Foxton's decision, and the Court of Appeal gave judgment in December of last year. The long and the short is that the Court of Appeal allowed the banks appeal and reverse the judge's decision on the speculation issue so that the swap contracts were declared valid and binding on Venice. The Court of Appeal's reasoning is quite interesting because it accepted that it could not and would not interfere with the judge's findings of Italian law, treating them like other findings of fact unless those foreign law findings were plainly wrong. However, the Court of Appeal made the point that there was considerably more scope to interfere with the judge's application of Italian law to the facts, especially when that question of what was the answer on the facts applying Italian law was not based on Italian expert evidence, but was the judge's own evaluation himself. The Court of Appeal considered that that was an evaluative exercise and that the Court of Appeal was just as able as the judge to form a view as to what was the correct analysis. The Court of Appeal very much emphasised the fact that the judge did not rely on expert evidence in order to find that the swap transactions were speculative under Italian law, and that essentially the judge applied his own evaluation as to what an Italian court would do if faced with that issue. The Court of Appeal noted that the Cattolica case did not lay down a test under Italian law for what was speculation, and indeed between the parties it was common ground that the test for a hedging transaction, which is a sort of counterpart to what would be a speculative transaction, that test for a hedging transaction was found in an Italian regulation which on the facts was satisfied in this case. In the event, the Court of Appeal found that the judge had made several errors of principle on the speculation issue, including a failure to factor in to his analysis the fact that the swaps which were the subject of the proceedings had replaced prior swaps which were themselves valid contracts which did not involve speculation. And essentially the reasoning being that if the prior swaps were not speculative, it was very difficult to then conclude that the swaps that replaced those swaps would themselves be speculative, And the Court of Appeal also relied on the fact that the exposure or the risk which was involved in the entry into the new swaps met that test under the for hedging under the Italian law. And so that led the Court of Appeal to allow the appeal and uphold the validity of those swap contracts. The Supreme Court received a petition for leave to appeal and has dismissed that petition, and so the Court of Appeal's judgment is the final word on the Italian swaps and capacity issue. Can I now then hand over to Tom to introduce, having laid that context out, the next section of our talk?
I wanted to discuss now more generally how the English court approaches foreign law issues and foreign law evidence, which is hopefully something that all of you will have experience of dealing with, particularly in banking and financial services cases. As you'll no doubt all know, English and other common law systems treat issues of foreign law as an issue of fact. Traditionally, that means the content of foreign law can only be proved at trial by reference to evidence of its content from an apparently qualified expert witness. One can find statements to that effect going back to cases in the 19th century, to the effect that the English judge does not have the organs to understand the content of foreign law and requires an expert to familiarise him with it. However, as several more recent courts have observed, foreign law is clearly a question of fact of a peculiar kind. It concerns facts about what the law of a particular system is, and determining those facts inevitably requires some degree of legal analysis of the competing arguments and their cogency. As Mr. Justice Foxton has written extrajudicially, the process of cross-examining foreign law experts can bear far greater resemblance to the Socratic dialogue between bar and bench when making legal submissions than to the cross-examination of witnesses of fact or even of experts in other disciplines. And more recently in Brownlee and Four Seasons, Lord Legate in the Supreme Court observed that the old notion that foreign law materials can only ever be brought before the court as part of the evidence of an expert witness is outdated. Whether the court will require evidence from expert witnesses should depend on the nature of the issues and the nature of the relevant foreign law. In recognition of those statements and reflecting the increased prevalence of foreign law issues in the English courts, the 11th edition of the Commercial Court Guide in 2022 introduced a more flexible approach. And we've put the relevant parts of paragraph H3 on the slide. In summary, subparagraph 3 contains a menu of options for determining foreign law issues, ranging from the traditional approach of full expert oral and written evidence to a more streamlined approach where sources of foreign law are established by way of judicial notice and supplemented by submissions from English counsel. Subparagraph 4 then provides a list of factors for the court and the parties to consider when deciding which option may be preferable for their case. So while none of this changes the strict position that questions of foreign law are issues of fact, it's an important distinction when it comes to appeals, the Commercial Court now encourages far more flexibility in terms of the procedure for trying them, development which mirrors similar procedures adopted in other international commercial courts, such as the Singapore International Commercial Court, and a procedure that will be very familiar to arbitration practitioners. Our experience, speaking for us, I think, of the commercial court cases since the guidance is that foreign law issues have still tended to be tried in the traditional way, involving opposing experts, exchanging reports, and being cross-examined. And I think a reason for that, certainly in my experience, is that the very detailed consideration of foreign law issues and how they fit together with a party's case on English law and a party's case on conflicts analysis usually takes place much closer to the run-up to trial. And before all of that analysis and preparation has been done, parties can be understandably cautious about adopting a more streamlined procedure for foreign law issues, which may turn out to be inadequate. And the safest course then is to stick to the tried and tested procedure involving full expert evidence. So it's clear that making use of the streamlined options requires very early engagement with the foreign law issues and where they go to and how extensive they are. As noted at subparagraph D of the guide, which we've highlighted, I think, on the slide, an important factor when considering which option for foreign law expert evidence might be appropriate is the nature of the foreign law system and how closely related it is to English law. And I'm going to hand over to Jasbir now to say something about legal systems that might be at the more familiar end of the spectrum.
So, as the guide indicates, when you're dealing with a common law system of foreign law, then that at least raises a question as to whether the court can depart from what you might describe as the more traditional way of dealing with foreign law expert evidence. So the position is that if the foreign law involved is a case or is a system which is part of the common law system, English lawyers and frequently English judges will feel far more comfortable dealing with that legal system. The common law systems of foreign law will be easily accessible because the judgments will be written in English. Those systems of law operate in a familiar way because they will adopt the principles of stare decisis, and the judgments of the highest courts of the relevant common law jurisdiction will be usually easy to follow in terms of reasoning. So that, of course, raises the obvious question as to why foreign law experts are actually needed at all when dealing with common law legal systems. If the lawyers and the judges can read and understand the decisions of the highest court of a common law jurisdiction, why do you need to waste time on experts when one can simply read and argue the cases in court? Sometimes the answer might be that the parties think that they can get some kind of forensic advantage by deploying a very distinguished expert to add luster to their foreign law arguments. And also there is perhaps a reluctance to depart from the sort of all singing and dancing approach of foreign law experts and full written and oral evidence with cross-examination. What I would say is, whilst I would encourage all parties to consider in an appropriate case, as the guide suggests, whether dispensing with experts and or full oral evidence is appropriate with a common law system, I also want to sound a note of caution here, and I'm speaking also in my capacity as a US qualified lawyer, as a New York qualified lawyer. And that caution arises when dealing with the systems of law arising from the US, which one frequently encounters, in particular New York law, which is a very frequent system of law encountered in commercial practice. And whilst US law will be familiar to English lawyers, there are a number of features of US law which, if you're not familiar with, can make it very easy to misread US cases. One example is ignorance of US civil procedure, in particular the interaction between state and federal jurisdiction, and also the quite well-developed conflicts of laws principles that regulate the relationship between state law and federal law, together with the preponderance of jury trials, which can frequently lead non-US lawyers to be misled as to the true meaning of any US judgment. So whilst it might be easy to dispense with experts on the differences between English and New York law on, say, contract interpretation principles, for example, one relatively minor difference is that subsequent conduct is admissible in New York law, whereas obviously not admissible under English law. When you are engaging in perhaps more complex topics, such as, for example, what are the essential requirements for statutory torts recognised under federal law, that may very well be more unfamiliar territory, and that's probably an area where it will be necessary to obtain expert guidance. Moving on, I'd say a few words about civil law. Civil law systems of foreign law present very different challenges to the challenges presented by a foreign common law system. One can consider the example of Italian law, which was in play in the Venice case that we've been discussing. So Italian law has no doctrine of stare decisis. And that, of course, presents formidable issues, not just because the lower courts are not formally bound by the higher court, but also because the judgments are often relatively lightly reasoned, in part because they are not designed to guide lower court decisions. Another feature is that Italian law, like other civil law jurisdictions, divides the court system. So unlike a common law system, certainly like English law, where you have one single Supreme Court that decides all issues of private law and public law definitively, Italian law has a court system that divides jurisdictions between the Constitutional Court, which is the Supreme Court for matters of interpretation of the Constitution, the Council of State, which is the highest administrative court dealing with all public law matters, and then the Supreme Court of Cassation, which is the preeminent court for civil law, including commercial matters. So when, as in Venice, the issue about the local authority's capacity traverses potentially civil law, the Italian constitution, and public law, that presents a real challenge for an English court, and that is not assisted when the case law itself between the differing courts suggests that there is something of a jurisdictional tussle between the three court systems in a civil law system. So it's highly unlikely in that scenario that an English court could address the law of a civil law system without expert assistance and without going through the formal process of treating the expert evidence and the foreign law as a question of fact subject to cross-examination. Tom has had a somewhat interesting experience with a subcategory, or what we describe as a subcategory of civil law, which is a civil law system arising from a former colonial jurisdiction, which has a legal system which in part is based on the law of another jurisdiction. And I'll hand over to Tom to share his reflections on that experience.
So this is the Tuna Bonds case, which Richard and Laura have already spoken about at length. That plainly concerned a large number of issues of Mozambican law, and a large number of them were contended by the Republic of Mozambique to be issues that went to the actual authority of the Minister of Finance when he entered into the purported guarantees. As Richard and Laura have alluded to, we won't know the answer to whether or not they did, because those issues fell away as a result of the various bank settlements. But the last round of settlements were some time after trials. There was a full trial of the issues where the court heard extensive expert evidence from academic lawyers. And a recurrent theme in the Mozambican law evidence was the extent to which it was appropriate to view Mozambican law issues through the prism of Portuguese legal analysis. Mozambique, as some of you will know, was a Portuguese overseas province until 1975, and on independence it adopted a constitution modelled on the Portuguese constitution, which provided for a state apparatus similar to Portugal, and it transposed a great deal of previously applicable Portuguese law directly into Mozambican law on day one of independence. So it was unsurprising at trial to have experts on both sides who specialised primarily or to a large extent in Portuguese law, and it was common ground between them that Mozambican courts would look to Portugal legal sources and authority as influential. But there were a number of very important issues between the experts which turned on the extent to which Mozambican law could be collapsed into Portuguese law, or whether since independence Mozambique had taken a distinctly different direction to Portugal, such that Portuguese law and doctrine was irrelevant. Now, I'm not going to descend into the thicket of issues where this debate came out, but it does illustrate, I think, the need for special care when dealing with mixed jurisdictions like Mozambique. First, not to approach the jurisdictions from the perspective of an English common lawyer, but also not to collapse it into a civil law jurisdiction which may be more familiar, such as Portuguese law, or French law, or German law. Effective expert evidence in cases dealing with those sorts of jurisdictions can be really, really important in bringing out those fine distinctions for mixed jurisdictions like Mozambique. Jasbir, I think, is now going to introduce the last topic we wanted to touch on, which is selecting foreign law experts.
But before I do that, I should also mention that one also encounters from time to time systems of law that are neither common law systems or what you would characterize as civil law systems. One example that comes to mind is Saudi Arabian law. And that again poses challenges, which is difficult to see how you could address that via submissions from the bench, from the bar. That really has to be addressed via foreign law experts. But returning to the topic at hand, which is what type of foreign law expert to pick, the variety of foreign law systems and potential approaches to foreign law issues that are now accommodated in the commercial court makes it imperative for the parties to select the right foreign law expert. And generally, there are three types of expert to pick from, although you can have experts who have a variety of or a mixed experience. But those three types are retired judges, academics, and practitioners. And whilst it will always come down, in terms of who one picks, down to the individual and the requirements of the case, each type of expert tends to have their own advantages and disadvantages. And if we take first the retired judges, when you're dealing with a common law jurisdiction, a retired judge may seem to be an ideal choice. I mean, one can ask rhetorically, who better to know what the Supreme Court of a jurisdiction will say on an issue than the recently retired Chief Justice of that court, if you can get them. And a senior retired common law judge will usually require little guidance as to how to come across as authoritative when giving evidence to a commercial court judge. But again, I would add that it's not an invariable rule that such an expert, the recently retired Chief Justice of a Supreme Court, will find favour with a tribunal. And I've had relatively recent experience of an arbitral tribunal finding that the former Chief Justice of a state Supreme Court had not correctly interpreted their own judgment when they were sitting. I've also had the pleasure of saying the same, that a retired Supreme Court Justice of this jurisdiction has misinterpreted their own judgment when giving expert evidence in New York. And that experience reinforces, I think, the adage that once a judge gives a judgment, it is for posterity and not the judge himself to decide what he or she, in fact, meant. The next category is academics. So in some jurisdictions, retired judges are not available, or they are not as highly respected as eminent legal academics, in which case one will be looking at distinguished university professors as a potential suitable expert on foreign law. This is especially, I think, the case with civil law jurisdictions such as Italy or France. The disadvantage there is that those experts will need guidance as to how to present their views before an English commercial court judge. And if those experts are not fluent in English, that can pose an additional difficulty, which is why if your legal academic has a degree or some experience from an English-speaking university, then that can be a considerable asset when considering that expert over a non-English-speaking expert. Tom, I think you've got some your own thoughts on academics.
I'd just add, based on my experience, a problem sometimes with academics, by no means all, conscious might be some here, is that they can sometimes be a little less adept in cross-examination at dealing with hypothetical factual examples which test their opinion. I think often that's because it's been impressed upon them throughout the course of preparing their evidence that they mustn't opine on the ultimate issue for the court. The application of the law to the facts is for the court. But there can sometimes be a bit of a clash of cultures, I think, in cross-examinations when academics who approach the law from a more theoretical perspective are asked to test their conclusions by reference to assumed facts and practical implications, the sorts of points that we all know English judges can find quite persuasive. So it's important then to think, when you're instructing an expert, about their experience with how we do things in English litigation here. Another important consideration from a war story, although not my loss, I'm glad to say, is when instructing an academic, always check what they have published previously, because some academics can have said too much in a former life. So this was a case where the other side had instructed an academic who gave a report in very strident terms that a contract omitting a particular type of clause would be unlawful as a matter of German law. He said there was no doubt about the point. So you can imagine our utter delight when we found an article by the same academic written a few years earlier saying completely the opposite. This was a week before our expert put in his responsive report. And the expert's attempt in the joint statement to draw a distinction between his academic perspective and the perspective in his client's report was not very persuasive. So always check their publications and, of course, whether they've given evidence in prior proceedings and what's been said about that. I think that's all we wanted to say about academics. So the last type of experts are practicing lawyers. And this is actually now recognised under a new section of the Commercial Court Guide at subparagraph 3.5, which expressly acknowledges that parties will often have retained foreign lawyers to advise them, and in those circumstances it may not be necessary to go to the length of instructing a separate expert to give evidence at trial. A real advantage of practicing lawyers can be that they're likely to be more familiar with the procedure and requirements of litigation and have a better grasp of how the foreign law issues fit into your client's case as a whole. Returning to the case I just spoke about involving questions of German law, we had a positive experience on our side using a practicing lawyer from the outset of the case who was accustomed to dealing with distribution disputes under German law throughout his career. So he knew immediately what issues to address in terms of how the German court would approach these issues, and he could also address the very basic accounting issues that arose in the case because they were typical of the disputes he was accustomed to handling. The other side, who had instructed an academic, the academic had far less experience of these types of disputes, and they also had to instruct an accounting expert to deal with the basic accounting questions. Jasbir, I think you wanted to add some points on practitioners.
Yes, I mean, ultimately, I think the question the answer to the question whether to appoint a practitioner rather than a retired judge or legal academic will very much depend on the system of law, on how impressive that practitioner is, and on their ultimate ability to impress the commercial court judge. In one sense, the advantages and the disadvantages of a practitioner may mirror those of an academic. A practitioner can give real-world practical insight based upon experience before the relevant courts. But on the other hand, if the practitioner is overly focused on the facts of the case, which are not necessarily, or certainly not his province in the case before the commercial court, he or she may be unable to persuade the English court that the relevant principle of law is as you say it is, and it is not as what his or her opponent says it is. And whilst an inability to test a principle by reference to hypothetical facts may be a weakness in an academic expert, so too is an inability of a practitioner to convincingly articulate any coherent legal principles from a series of cases or from a foreign law, and an attempt to sort of merely distinguish statements of principle in a case by saying it has different facts is again not likely to be seen as very persuasive from the commercial court's perspective. Ultimately, whether to choose a retired judge, a legal academic or a practitioner, or to dispense with experts altogether will depend upon the foreign law issue, the system of foreign law that you're engaged with, and the attributes of your expert in each individual case. But we think that we've given you some food for thought on this frequently encountered and interesting topic. I know that we've got one of the editors of Dicey and a former commercial court judge in the audience, but if any others of you would like to make a contribution or ask a question, we'd be very grateful. I'm told we've run out of time.
Okay, we're going to kick off. I think we're slightly behind schedule, so I'm going to try and make up a little bit of time, although I'm not going to overpromise. Will and I are going to talk about crypto assets today, and specifically I will address the new bill on digital assets, which was introduced into Parliament just 3 weeks ago. We've tried to pitch this so that it will be accessible for those of you who haven't done any work in this sector yet, and yet topical for those of you who are already working in it. So this is the outline of the talk. I will start with a whistle-stop tour of key terms and concepts, including the different types of crypto assets that we see. Then I'll go on and explain why there is ambiguity as to their legal status at common law, as things presently stand, before we then look at the new bill. So what are crypto assets? They are digital units of account in which cryptography and open source software are used to regulate the generation and distribution of those units. So let's just break that down for a moment. They're digital only, they're backed by cryptography, and that's the name that describes the particular method of coding data. And then that cryptography is what ensures the security and reliability of the network. Open source, so that's also known as a distributed or open ledger. The term blockchain that you hear used refers to how data is stored on the shared database. That technology is stored in blocks, hence blockchain, and they're linked together using cryptography. So there are 3 subcategories of crypto assets, and they are cryptocurrencies, crypto tokens, and crypto securities. So what is a cryptocurrency specifically? It's a term that's often used erroneously in a very broad sense, which isn't particularly helpful. In fact, it should be distinguished from both crypto tokens and crypto securities. So you'll hear it said that there are thousands of cryptocurrencies in the world, but to be more precise, there are several dozen cryptocurrencies or coins, and there are thousands of tokens. On this slide, I've included what a cryptocurrency is as defined by the European Parliament back in 2018, and I still think this is an excellent summary. Again, we see digital, peer-to-peer. Because we're dealing here with a cryptocurrency rather than another type of asset, they are described as a general purpose medium of exchange, and they operate independently of any central bank. Obviously, that links back to them being peer-to-peer. We see they're secured by cryptography, as I've already mentioned, and they are capable of being converted into legal tender. So again, that's because it's a cryptocurrency. So different types of crypto assets. Again, looking first of all at cryptocurrencies in the narrow sense, or coins, they belong to networks that have been built from the ground up. So that means that they're on their own dedicated blockchain. And coins are earned by computers that process transactions for that cryptocurrency network. So, for example, BTC, which is the symbol that you see on the top right of the slide, that's the coin that's earned by the computers that process transactions on the Bitcoin network. So that's why it's a proper cryptocurrency or coin. By contrast with cryptocurrencies, crypto tokens are much easier to make. They don't have their own dedicated blockchain that's built from the ground up. In general, they're built on an existing blockchain and typically Ethereum. And that's why we see that there are thousands of them. Some tokens resemble traditional instruments like shares, but you also have tokens that are utility tokens, so they give you access to certain products or services. And the NFTs that you hear about are actually tokens, and they function as digital certificates of ownership. Crypto securities are investment instruments. A security token may, for example, represent the rights of ownership that have been tokenized on a blockchain. So taking you back briefly to law school, let's just consider what property is. The common law has traditionally recognized two categories of personal property: things in possession and things in action. Things in possession generally being tangible things, hence why you can possess them, and things in action being something else. It's a category that's much less clearly defined. On a wide view, it's everything that can't be put into the things in possession bucket. On a narrower view, it's things that can only be claimed or enforced by legal actions or proceedings against another party. So, for example, a debt, a right to sue for a breach of contract, or shares in a company. On that narrower view, things in action have no independent form. They exist only insofar as they're recognised by a legal system and they can be enforced against another. In the 19th century case of Winnie, it was said that these two categories of personal property were exhaustive. But what we've seen in many cases since is that there have been indications to another effect, that there might be another category. So pausing there, let's reflect back on what I've said about crypto assets. It seems that in general, they can't be things in possession. As I've mentioned, they're digital and therefore intangible. But at the same time, they exist in this distributed ledger system. So you can't really conceive them as rights or claims that exist only insofar as they are brought against another entity. Rather, they look like they can be used independently. So they're not like debts in that sense. If you imagine a world in which crypto assets were not legally recognised whatsoever, it wouldn't mean that they simply therefore cease to exist. And so in that way, they're very different to things in action if they are narrowly defined. They're not coextensive with the rights associated with them. There is something external that you can point to, namely the token itself. So let's have a look at what the case law has said about this issue so far. the best judgment to go to, in my view, remains that of Mr. Justice Bryan in 2019 in AA and Persons Unknown. And that case concerned an attempt to retrieve BTC, so Bitcoin the coin, paid following a ransom demand to bring a hack to an end. Mr. Justice Bryan ordered a proprietary injunction over the BTC that had been paid. And the key paragraph of his judgment I've popped on the slide. He refers to a paper, and I'll come back to that on the next slide. He says, crypto might not be a thing in action if that category is narrowly defined, but that should be no bar per se to it being treated as property. And then he refers to Wilberforce's 4 criteria in Ainsworth, and he concludes by saying that for the purpose of granting interim relief, he finds BTC is a form of personal property. So just pausing there, what he has actually found is there was a serious issue to be tried on that topic, not that BTC was definitively personal property on the balance of probabilities. That would have to be heard at a final judgment if that progressed on to trial. So just touching back on the paper that Mr. Justice Bryan referred to, that remains an important sort of backdrop for this area. It was produced in November 2019 by the UK Jurisdiction Task Force, and that was chaired by Sir Geoffrey Voss. And what he said is, in conclusion, crypto assets come in all shapes and sizes, as I've already tried to explain, and in general terms, they are to be treated as a matter of English law as property. And he said that was for 2 key reasons. First, their novel features themselves do not disqualify them from being property. And secondly, the very fact that you can't put it into one of the traditional subcategories, whether it's things in possession or things in action, that itself ought not to be a bar to it being legal property either. So since AA and that legal statement, what we've had is a raft of High Court decisions where the court has similarly found there was a serious issue to be tried as to whether various crypto assets could constitute property. I think there have now been 26 cases in total. And whilst they generally concern cryptocurrencies, and specifically BTC, occasionally the courts have considered tokens, and that's what I've popped on the last 3 bullets of the slide. It's worth mentioning Tulip as well. That was the Court of Appeals judgment, and they implicitly agreed that there was a serious issue to be tried as to whether BTC constituted personal property. But as yet, we've had no final judgment, so nothing on the balance of probabilities that crypto assets are in fact property. Just pausing there for a second, it's worth mentioning that this debate is not, of course, unique to crypto. We saw in Armstrong, which concerned an EU carbon emissions allowance, that those sorts of concepts can be personal property, even though they couldn't be categorised into either of the traditional 2 subcategories. But in relation to crypto assets, there is particular concern. And that's partly because so many of the features of crypto assets are novel, which means that the jurisprudence is extremely sluggish to develop, which is why we've seen 26 interim remedy cases, but none as yet going to trial. For that reason, there have been many calls for legislation to clarify the status of crypto assets. And so enter stage left, our new bill. This has been introduced with great hype on the English government website. So I thought I'd rather start with that because it rather raises your expectations about what the bill will say. They say previously digital belongings were not definitively included in the scope of English and Welsh property law, leaving owners in a grey area. And so you rather think, well, when enacted, this bill will definitively include crypto assets within the scope, and the debate will be ended, and I'll have to finally find a new topic to talk about at the next conference. But let's have a look. These 2 clauses are the totality of the bill, so it's not necessarily a brilliant start. Clause 1 says, a thing, including a digital or electronic thing, is not prevented from being property merely because it is neither a thing in possession nor a thing in action. Now, if you're like me, by the time you've read Thing for the 4th time, you rather become plagued with images of the Thing from the Addams Family, or if you're Gen Zer, the Netflix Wednesday series. But, you know, levity aside, Clause 1 is saying that crypto assets will not be stopped from being recognised as property simply by the virtue of the fact it can't be put into one of the traditional 2 subcategories. That's sort of it when you first read it. So you think a bit anticlimactic. But in my view, it's actually a bit worse than that. I think this bill is actually potentially problematic, and I'd be very keen to hear about other people's views on this, and perhaps I'm over concerned about this, and actually you disagree and think that the reading of it is much less problematic, but let's get into it. When you read it again slowly, I think that what this is saying is that crypto assets are not things in possession nor things in action. They're sort of signalling that from the wording. They're saying a thing, including digital things, so crypto assets, isn't prevented from being property because it is neither a thing in action or a thing in possession. So, pausing there, what it's saying is that digital things, including crypto assets, will fall within this new 3rd category of thing. And that reading is supported by the explanatory notes, which says at paragraph 7, digital assets do not easily fit within the traditionally recognised categories. They are better regarded as belonging to a separate category of personal property. But pausing there, with what we looked at AA and the legal statement, the case law never went that far. What we saw was judges expressing concern that crypto assets might not or might not easily fit within the 2 traditional subcategories, not that they definitively didn't. And I think that suggesting the category of things in action should be narrowly construed is therefore something that we should be slightly cautious about. That runs against a long history of cases that support a much more flexible and expansive interpretation of the thing in action category. And in so doing, we will be going against the approach taken in other jurisdictions, such as Singapore, in the case that I've put on the slide. But most troubling for me, I think it will indicate to the court that they ought to approach all crypto assets in the same way. They will see them as part of this whole new world of digital things, rather than carefully looking at each individual crypto asset and analysing it individually on its merits. And as Voss says, they come in many different shapes and sizes. Another concern that I have when I continue to read this bill, and its many mentions of thing, was that the scope of the category of thing in action is itself uncertain, and in fact that's one of the raison d'etres of the bill, is to remove some of that uncertainty. But it's quite surprising, therefore, that this bill, being only effectively 1 clause long, defines the scope of this new 3rd category negatively by reference to a thing in action. So they actually use that term of art, and there's no attempt whatsoever to define it. So you start to rather wonder, will this actually create further legal certainty, or is it actually going to just add more and more uncertainty? In particular, when you start to consider what proprietary rules will apply to this new 3rd category. We've got an established web of proprietary rules, such as in relation to title, perfection, priority, innocent inquirer, and how they interact with the different traditional categories. So how is it going to work with this whole new 3rd category of thing? Likewise, what defences will be available? Would a good faith purchaser defence be available to this new 3rd category, or certain parts of it? So I've had a bash at tweaking the wording of the bill to see if I can avoid the aforementioned negative consequences. I think this deals with the first issue that I have flagged, which is that it leaves it more open to the courts to determine whether a given crypto asset could be a thing in action. So it sort of indicates, well, they could say it's a thing in action, or they could pop it into this new 3rd category, but without sort of overreaching the bill's stated aims and sort of going long away from what the case law has actually determined so far. And I also think it avoids using that term, thing in action or shows in action. And so with that, will hopefully bring a little bit more certainty. But I'm very keen to hear on other people's views as to whether I've overblown problems with the Act and whether my solution actually does anything better. So to conclude, the debate as to the status of crypto continues, whether it's property or not, I'm afraid. So we're still here. I think I've been giving this talk for, 6 years now. The new bill is not as definitive as the government website promised. And indeed, in my view, the extant wording of the bill may have many other negative consequences, whilst it may be that some tweaks to the wording could alleviate some of those concerns. And so I'm going to hand over to Will now, who will talk to you about BSV and a claim that might actually provide some final judgment on the status of at least one type of crypto asset as property.
Thank you. So this is a class action brought under the opt-out procedure in which I act for the class representative, and it's on behalf of all UK investors in a particular form of cryptocurrency called Bitcoin Satoshi Vision, or BSV. BSV is the product of a split, or what's known in the industry as a hard fork within a blockchain. So in this case, Bitcoin Cash was a hard fork of Bitcoin, and BSV was a hard fork of Bitcoin Cash. The most public representative of BSV is the computer scientist, Dr. Craig Wright, who has claimed to be Satoshi Nakamoto, the inventor of the original Bitcoin. That claim has been subsequently discredited by judgment of Mr. Justice Mellor earlier this year, although that's not particularly relevant for the purposes of this case. BSV, as a result of the involvement of Craig Wright, has been subject to significant industry controversy, given his claims to be the real Satoshi. And we contend that this led to a series of tweets from various cryptocurrency exchanges over a very short period, and those cryptocurrency exchanges were Kraken, Binance, Shapeshift, and Bitterlicious. A very short period from 12th of April 2019 to 19th of April 2019, where the exchanges sought to denounce publicly Wright as a fraud and announced an intention by those exchanges to delist BSV, which they then proceeded to do, so it was delisted from their platforms. Binance and Kraken went a little bit further and required users or investors in BSV to withdraw their holdings within a few months, otherwise they would lose access completely, although Kraken subsequently converted those holdings into Bitcoin. The claimants contend that this delisting process was unlawful and anti-competitive, and they're bringing a competition law claim. But what I'm going to focus on today is the damages aspect of that. So the claimants comprise three different subclasses. There were those who were able to and did sell their BSV, which we refer to as subclass A. Those who did not, which we refer to as subclass B, and those who were subject to the extra measures taken by Binance and Kraken. Now, the damages claimed for subclass A are calculated by reference to the difference in value at BSV at the point of sale. For subclass B, the claim is for what has been characterized as a foregone growth effect, which is the lost opportunity for BSV to become a major cryptocurrency, and that makes up the largest part of the claim. Subclass C is a bit of a blend. So as it equates to the foregone growth effect for the Binance holders, save that because the coin has subsequently been taken or no longer accessible, the value of the coin left in the holder's hand is nil, so there's no credit that needs to be given for whatever BSV might be left. And for Kraken holders, it's similar to the approach with regard to subclass A, because it's been converted into Bitcoin, but there's an additional claim for the fee for the conversion of that BSV to Bitcoin. So it's quite an interesting case, I think, for a few reasons. There's the fact that BSV is quite current in the news anyway, but it's going to examine the extent to which our unlawful collusions operate in the public domain. And also, I think it's going to need to grapple with issues about how a new form of property, however we characterize that new form of property, is to be quantified in damages counterfactuals. So earlier this year, Binance issued an application for strikeout and reverse summary judgment on subclass B. Their position was that by reference to the market mitigation rule, sometimes called the breach date rule, there can be no claim for the foregone growth effect because a holder of BSV, following the delisting events, would be expected to go into a market and find a like-for-like replacement for their BSV. It's just a bit of recap on the market mitigation rule. I put up the quote there from Lord Brown in the Golden Victory. Essentially, it applies where there is an available market for whatever has been lost, and its explanation is that the injured party should ordinarily go out into that market to make a substitute contract to mitigate and generally thereby crystallize his loss. Market prices move both up and down, and if the injured party delays unjustifiably in re-entering the market, he does so at his own risk. Future speculation is for his account. So this rule, if you like, bridges causation and mitigation. The innocent party is deemed to have gone into the market to mitigate their loss because the law assumes that that conduct is the reasonable thing to do. If they do not go into the market, then the decision is an independent speculation, such that any loss caused by not going into the market is a result of that independent decision and not caused by the breach. So the corollary is also true in the res inter alias acta cases, because any gains made by an independent speculation do not need to be credited against the loss claimed from the defendant. That loss remains causatively fixed by reference to an assumed entry into the market. But critically, there needs to be, for the market mitigation rule to apply, an available market in which a replacement can be sourced. So I put up here the quote from Lord Tulson in Bungi and Nadira, and he said, "There are three important things to note about measurement of damages by reference to an available market. First, it presupposes, this may be thought self-evident, but it presupposes the existence of an available market in which to obtain a substitute contract. And secondly, it presupposes that that substitute contract is a true substitute for the thing that you have lost." And the claimant, it goes on to say, the claimant is not entitled to charge the defendant with the cost of obtaining superior benefits to which the defendant contracted to provide. And the third point is relevant to the differences of how you would actually calculate the loss. So how does this work in the context of cryptocurrencies? So crypto is not a fiat currency or a traditional form of currency. So it's not a question of simply valuing one form of currency against another by reference to an exchange rate fluctuation or something like that. It's also not really a question of just selling or cashing in your crypto. That's not really about obtaining a substitute. That would be about liquidating the asset. So it's a form of property, or we think it's a form of property, but what is the market? Different cryptocurrencies may have different characteristics and risk profiles. So how does one identify a true substitute? And this raises a question as to how useful the market mitigation cases, which usually arise in sale of goods or charter party contexts, are really appropriate to ascertaining a way of assessing loss in this new sphere of property. Is interchangeability really possible? And that leads to my question I put on the slide about the degree to which there is a market at all, and whether there really is, whether a crypto asset is almost too unique to find a substitute. Is it like real property or unquoted shares, which are often can be capable of subject to orders for specific performance, in circumstances where they are considered unique, you can enforce a sale contract in respect of them. And if there isn't a market for a crypto asset that you can enter into to find an appropriate substitute that is a true substitute, then we're into the realms of the no available market cases. And in the no available market cases, you need to look at other forms of mitigation. So then there'll be questions about what those forms of mitigation could be in the crypto sphere. Would you have to cash it in? If you've cashed it in, would that still mean that the foregone growth effect, going back to subclass B, is suffered? I've also raised a question at the bottom of the slide about how this operates in multi-party claims generally. So this is a class action on behalf of, as I said, all investors, UK investors in BSV. Now, the law might deem the claimant to go and do something which is considered to be reasonable by reference to a market. But how appropriate is that as a methodology in circumstances where there may be thousands and thousands and thousands of claimants with individual characteristics and differences? There's also a related point which concerns the fallacy of composition. So if, for example, the thing to do was to sell the crypto and go into the market and find a substitute, and they all did that, that would cause the value of the BSV that was being sold to crash. And there's a question mark to the degree to which that should be borne into the approach to damages, or whether that is simply part of the quantification exercise. The tribunal was of the view that the class representative's expert evidence, which was designed to demonstrate how the loss would be valued by reference to how alternative cryptocurrencies had grown during the claim period, was sufficient to allow them to conclude that there was an alternative substitute market. So these questions were not really addressed in the tribunal's decision. And the tribunal said that the awareness of a BSV holder of the delisting events, i.e. the decision by the exchanges to remove BSV from their platforms, was a matter for trial. So that is something that will still need to be grappled with, because it will only be when one is aware or reasonably aware of the breach that the obligation to go into the market would be triggered. But the tribunal, in doing this, did seem to apply a conventional approach to damages to crypto. But at some point, I suspect some of these questions are going to need to be grappled with in more detail, and giving rise to the sort of points that I've identified in light of what Sarah said. I'm told we don't have time for any questions, but we'll be more than happy to take some over drinks.
Very much, everyone. We are going to be quite quick and whip through this. Ordinarily, 20 minutes to talk about banking and sanctions would be quite tight, but we will rattle through. I'm going to give a very brief general introduction to this topic, and Fred is then going to talk about one particular issue and one particular case before we briefly discuss and wrap up. So as a general matter, as everyone here will probably know, the world of banking has been pretty much turned upside down when it comes to sanctions compliance over the past couple of years. First of all, as a result of Brexit and the need for the UK to have sanctions regimes of its own at all. And secondly, by Russia's invasion of Ukraine and the incredibly swift pace at which financial institutions have had to implement restrictions, amended restrictions, designations, and so on in unbelievably quick time. I think the main thing characterizing this area from a banking perspective is the extreme degree of uncertainty in a lot of the legal rules that come out about sanctions compliance in a context in which there is now strict liability on banks. So if they get it wrong, they can be up for serious penalties on the basis of strict liability. Very onerous reporting restrictions on banks to report to the sanctions authorities in the Treasury, sanctions breaches, but also frozen assets, very, very onerous reporting obligations and obligations of due diligence. The context so far has not been one in which there have been large numbers of fines, but I think that is starting. Not only OFSI, the sanctions part of the Treasury, but the FCA just a few days ago published a sanctions breach decision relating to Starling Bank, which is quite interesting. But the main focus so far has been on compliance by the banks rather than public enforcement. But as I say, that will change. And a final point on this is that there hasn't been much help from government, by which I mean there is quite a lot of guidance coming out of government on how to comply with sanctions. But if you're a financial institution and you want a swift answer to what a restriction means, or indeed you want a license, an exceptional authorization to be able to route a transaction, it would be quite an unusual case in which you get an answer from government swiftly or possibly at all. So it's a difficult context. There are a number of cases starting to come through the courts and arbitral tribunals which raise all sorts of commercial issues about sanctions. A lot about when contractual obligations are frustrated or otherwise affected by the imposition of sanctions. Lots of cases on sanctions clauses, force majeure, illegality in foreign sanctions law. There's a huge range, and we would need and probably should have a special conference just on all of that. But what we thought we would do is focus on one or two issues where there have been particularly focused issues which I think nicely illustrate some of these introductory points from the perspective of banks having to deal with financial sanctions. And one of them is a case that Fred was involved in called Celestial Aviation, and I will leave it to Fred to tell you all about it.
Maya, thank you very much. So, as Maya mentioned, I'm going to be talking about this Court of Appeal case, Celestial and Unicredit. The decision was handed down in June, so a couple of months ago, and it raises a number of important issues over the application of sanctions to banking transactions, and as we'll see, illustrates a number of the themes which Maya highlighted at the outset. So the case was about letters of credit, which I call LCs. And the LCs were issued in connection with leases of aircraft entered into between Celestial, which is part of the AerCap group, and two Russian airlines, which were the lessees. And the LCs were issued in favour of Celestial as security for performance of the lessee's obligations. So in simple terms, they can be thought of a bit like a guarantee, but importantly, the payment obligation is autonomous and therefore in no way dependent upon any claim which may or may not exist under the underlying lease. Unicredit was the confirming bank, and so it was obliged to pay out under the LCs if demand was made. Now, importantly, at the time the leases were entered into, and at the time the LCs were issued, those activities were perfectly lawful. There was, at that point in time, no prohibition on supplying aircraft to Russia or extending financing to enable or in support of any supply of aircraft to Russia. That all changed in March 2022, immediately following Russia's invasion of Ukraine. And at that point, there was a significant ramping up in the UK sanctions regime vis-à-vis Russia. And for the first time in March 2022, there was a prohibition on the supply of civilian aircraft, and there was a prohibition on the financing in connection with a supply of civilian aircraft. And that is the prohibition which is referred to as Regulation 28 in the Celestial case. And a week or two after that, or a few days after that, there was a default under the leases, and Celestial made demand under the LCs, thus crystallising the payment obligation. UniCredit, which would otherwise be obliged to pay out, refused to pay on the basis that UK and US sanctions stopped it from doing so. And the case gave rise to three main issues. The first was the Regulation 28 issue, i.e. the UK sanctions issue. Did that have the effect of suspending or rendering unenforceable the payment obligation under the LC? The second question, referred to as Section 44 as Samler, is the interpretation of a statutory defence in the sanctions legislation, which in simple terms applies if you do something in the reasonable but mistaken belief that what you're doing is in compliance with UK sanctions. And the third issue was a conflicts question, which is whether the fact that payment was required to be made in US dollars meant that US sanctions came into play and affected the enforceability of a payment obligation governed by English law. I'm going to focus on the first of those three issues, the UK sanctions issue. So the issue there is, did the prohibition which came into force in March 2022 have the effect of prohibiting payment under LCs which were opened many years earlier? Now, Regulation 28 is a bit of a mouthful, but it's got three main components. I will just simplify it and summarise it. It says a person must not, 1, provide financial services or funds, 2, in connection with, 3, an arrangement whose object or effect is the supply of, quote, restricted goods, which includes civilian aircraft from March 2022 to Russia or people in Russia. The commercial court held that the payment obligations were not affected, and so UK sanctions did not excuse UniCredit from making payment. And just to give a bird's eye view as to the reasoning of the commercial court, it took a heavily purposive view of the regulations. And it said, in substance, that Regulation 28, when it came into force in March 2022, was intended to apply prospectively, and its purpose was to stop financing which allows you to buy aircraft to be sent to Russia. And the prohibition did not apply because the LCs in this case were opened before Regulation 28 came into effect, and at a time when the supply of aircraft was perfectly lawful. And all that was happening, the court said, is that a German bank was required to make payment to an Irish company under an autonomous payment obligation, and prohibiting that payment would have no effect on any Russian person, and it would do nothing in the slightest to further the policy objective underlying the regulations. UniCredit appealed to the Court of Appeal, and its appeal was allowed in the decision handed down a few months ago. And the Court of Appeal held that payment under the LCs was, quote, in connection with the supply of aircraft and was therefore prohibited under Regulation 28, notwithstanding that the LCs were issued and the leases were entered into many years before Regulation 28 came into effect. So the Court of Appeal took more of a literalist approach. It was unfazed by the fact that the prohibition would not, on the facts of this particular case, further the policy objective of stopping aircraft getting into Russia. And at paragraph 66, the court said that sanctions regime is a relatively blunt instrument that's intended to cast the net sufficiently wide to ensure that all objectionable arrangements are caught, and that approach obviously risks catching arrangements that may not be seen to be within the overall mischief. But the Court of Appeal said, well, your remedy in that situation is to go to OFSI, the licensing authority, and to get a license if the particular transaction you're dealing with isn't one which has a Russian nexus and therefore falls outside the mischief underlying the regulations. So it's a very clear divergence in approach as to the interpretation of the sanctions regime as between the commercial court and the Court of Appeal. And I think the main takeaway from this case is underlining the point that Maya made at the outset, which is the extreme uncertainty when it comes to construing sanctions legislation. The commercial court took a robust view, essentially said, come off it, this payment transaction has nothing to do with Russian parties, it shouldn't be caught. And the Court of Appeal said, well, no, if the transaction comes within the scope of the language of the regulation, that's the beginning and the end of it, and your recourse is to OFSI. That's easier said than done in terms of asking, does it come within the language of the regulations? Because there's an enormous elasticity built in to the wording of the regulations. For example, the word arrangement was extremely important in construing Regulation 28. And there was a big debate in the Court of Appeal as to what that meant. Did it mean the lease, entry into the lease, or did it refer more widely to the ongoing currency of the lease over, say, 10 years. There's a permission application to the Supreme Court pending, and so the Court of Appeal's decision may or may not be the final word, but it is likely to be emphasised, were there to be an appeal, that the effect of the Court of Appeal decision is to create considerable uncertainty for market participants. And it is likely to be said that in order to know where you stand in terms of is your transaction caught by sanctions, yes or no, you want to ascertain the position from the wording and the purpose of the regulations, and it shouldn't depend on you going off to OFSI to see whether or not they choose to exercise their discretion as to whether to be exempting your particular transaction. And of course, this is in the context of a regime which imposes both criminal liability and also, as Maya mentioned, strict liability for hefty penalties. And again, that uncertainty, the theme which Maya emphasised at the outset, is something which is, on one view at least, illustrated, if not exacerbated, by the Court of Appeal's decision, and could well lead to increasingly defensive practices on the part of banks. So with that, Maya, I'll hand back to you.
So a few brief reflections. As some of you in this room know, there are lots of other aircraft leasing related bits of litigation going on around the world. So this context of planes being grounded in Russia has given rise to lots of not just insurance disputes, but insurance, banking, and so on. And I think the problem facing the bank of basically how do you interpret one of these incredibly broad trade restrictions. So is payment or is payment not funds in connection with an arrangement whose object or effect is making aircraft available for use in Russia is an extremely difficult question that banks are facing sort of every day. One of the interesting things about this case is that it's a Part 8 claim for a declaration. And I think one of the trends in this area is that parties are seeking recourse to the courts to declare the position either way in a Part 8 claim, partly because there is such a need for certainty in this area that that's one of the routes, sometimes a much faster route than trying to ask the government for its view. I think along the same lines, I mean, one of the other issues in the case, as Fred mentioned, is when does a bank or anyone else have a reasonable belief that they are acting because sanctions say that they can't pay, for example. So that's the Section 44 of the Sanctions Act issue. And Fred, I don't know if you want to say anything about this in particular, but I think one of the big issues here is what does that mean for a company, whether it's a bank or anyone else trying to comply with sanctions? Should you be, for example, leaving a paper trail showing that you took advice, and as long as you took advice and acted reasonably, that's enough? There's some discussion in the judgment about whether it's subjective or objective, but just very briefly.
Yeah, no, so it involves both a subjective and an objective layer. So you have to genuinely believe that sanctions apply, and that has to be a reasonable belief. So as you say, in terms of evidencing the subjective belief, obviously documenting it and so on is obviously very important. Legal advice is a bit more difficult, because relying upon legal advice obviously creates issues as to waiver of privilege and so on, but at least arguably reliance upon legal advice is an asset, if you like, but would raise obvious privilege issues were that to be relied upon. But then on the objective question, that's simply for the court to take a view. Does the court consider that the view is objectively a reasonable one?
And then I suppose the last point in the case, which is what is the effect of US law on this? Again, a very common situation in a sanction scenario, because in addition to the other headaches that I outlined at the beginning, there are many overlapping and sometimes inconsistent sanctions regimes that particularly banks, obviously with international exposure, have to be dealing with. And the issue that's now quite often coming up in the English courts is what is the effect on a contractual or other situation of the fact that a contract might be unlawful to perform, or a transaction in another legal system, often US law. So that's the sort of Raleigh Brothers US illegality point. I don't know if you want to touch on that.
Yeah, just touch on very briefly. So the payment obligations in Celestial all governed by English law. So the general positions, the starting point is that any foreign law is irrelevant unless you can engage, as you say, the Raleigh Brothers exception. And that requires two things. First, the contract requires an act of performance to be taken, in this case, in the United States. And secondly, that act is illegal as a matter of US law. And the case law distinguishes between an act of performance per se, where the Raleigh Brothers principle is engaged, versus, on the other hand, an act which merely equips you to perform. And so the distinction is a somewhat elusive one. And the question here is the use of a correspondent bank in New York, which 99% of the time it will be said is necessary to be effecting a US dollar payment transaction, is that an act of performance such that the Raleigh Brothers principle comes into play, or is it simply equipping you to perform, and the payment obligation is simply making the payment in England, and how you get the money to England isn't part of the performance bucket, so to speak. Now, the Court of Appeal didn't actually need to grapple with that question because it held on the particular facts that US law couldn't be relied upon because UniCredit had not made reasonable efforts to obtain a license in the US. So it does leave open a number of conflict questions, which are very interesting, quite thorny questions, which remain open questions.
And also, if I remember rightly, an issue about if payment can't be made in US dollars, does reasonable endeavours to make payment include making payment in cash, which I think for a very large sum was suggested by the High Court as being reasonable, to the surprise of quite a lot of finance.
Indeed, so it was a $46 million payment. The commercial court said, well, if you can't make it by bank transfer, you can pay it in cash, and it relied upon a 1989 decision, Libyan Arab Bank. But the Court of Appeal distinguished Libyan Arab Bank because in that case a demand had been made, and here it said the contract was different and no demand had been made. So yes, in terms of that cash point, it certainly knocked the cash point on the head.
So I suppose a final word on this, because obviously our theme has been the great uncertainty for financial institutions, but I think it's worth highlighting a couple of issues likely to come up on this. So there are some very basic aspects of sanctions which are still extremely unclear for banks and others. One, perhaps somewhat surprisingly, is who is subject to financial sanctions. This is something the banks are having to grapple with every day. I don't know if we've got any bank compliance people here. But what do I mean by that? The financial sanctions rules, so this case is about trade sanctions. The financial sanctions, which are the asset freezing rules, apply not just to people who are expressly listed on the government sanctions list, but to companies that are owned and controlled by the people expressly listed. And how one works out who those are has become an extremely fraught and complicated issue, which is also going to be determined by the Supreme Court, I think, if not next term, then very soon. Why is that? Well, the test for determining whether companies are controlled by the designated people listed is very broad and very subjective. It's whether it's reasonable to expect that that sanctioned person would be able to achieve the result that the affairs of the company are conducted in accordance with his or her wishes, if he chose to, in most cases, insignificant respects, by whatever means, directly or indirectly, and having regard to all the circumstances. That is literally the test that the bank is having to apply every time it is asked to route a transaction. And that, as you can imagine, that has been quite challenging. The courts between themselves have completely disagreed with each other about what that test means, both at the High Court and Court of Appeal level and between different judgments. Happily, hopefully, it may be decided by the Supreme Court. It's particularly complicated by the fact that President Putin and other senior members of the Russian government are themselves sanctioned, and on one broad view could be said to control all companies in Russia on that test. But there is a very similar dynamic to the one Fred outlined in the Celestial case between the judges who say, look, these rules are what they say they are, they're very broad, and we judges have to interpret them to mean what they say, and they're very broad. If the government wants to narrow them, it will. And those who try and narrow them by some sort of perhaps more pragmatic or practical way of viewing, well, what does it mean for a person actually to control a company? So lots of different views on that. And just a final plug for some certainty in this area. I have a website, globalsanctions.com, which tries to track developments in sanctions law every day. We sometimes find we have up to sort of 10, 12 developments in sanctions every day. So do have a look at that. There are free updates if this is an area that interests you. And thank you very much for listening.